Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, we got Tim Felice with us here today. He's all the way from West Palm Beach, Florida. And Tim and I have been knowing each other for, far back as I can remember. I don't remember a memory where Tim Felice didn't exist in my world. So, Tim, when did we first meet?
Yeah, dude. It was like, I think it was 8 years ago. I had seen a video of someone's YouTube video of a Trojan horse opening. And I had looked you up, and you were going to do one in Florida, in South Florida, in Palm Beach County. I think like Delray or Boynton. And then we had the hurricanes. Remember? We ended up with an Airbnb because the hotel was closed.
Right. They closed down the hotel. I think it was like an Embassy Suites or something in West Palm Beach. I tried to cancel it because it was only Tim and like 3 people from his firm coming. And I'm like, I don't need to come down. And people are like, oh, you can't go down to, it's dangerous. There's a lot of mold and you could get sick and all this stuff. I'm like, I don't need to come. And what was your response to that, Tim?
I was like, well, no problem. But I can't go anywhere else.
No, that wasn't it. You were like, no, you have to come to this. You have to do it now. I've set this time aside. My whole team has set this time aside. We're counting on you. I'm like, well, all right, then I'll be there. And we rented out some little house, an Airbnb, and we did it at this house. And there's like, besides your firm, there's a few other people there. I have trouble remembering who they all were, but it was fun. I'll give it that. We learned a little bit and had a good time. So
Peter Dyson, Mark Hansen, JB. Trying to think of who else was there. Oh, Eggenberg.
Eggenberg was there too?
Yeah, he came in day 2.
Eggenberg, that's right. That's a good memory. Eggenberg. All right. So it's been a long journey since then. And remember, we worked on a couple guys that worked with me, Kyle and other folks helped you on framing a slip and fall case in a gas station. And then you got a good result on that. And I remember the first time we did the horse in action, which was a hybrid of Trojan horse. It was like the lecture, kind of a new format that actually Jacob Norman came up with, who works with Nick Rowley now and is the leader of Trial Flourish for Justice. He's like, you got to do like a lecture-based stuff because people like that stuff. I'm like, I hate that shit. People don't learn that. No. You got to do it. You got to do it. You got to do it. That's what people want. And so we did. And then you presented there. I can't say the rest is history because there's a lot of stuff going on between all of that got you where you're at today, which is finally got your first 8-figure verdict. So we're going to talk about that in a little bit. That's how we got to be knowing each other. But Tim, you've been a lawyer now for how long?
Going on 20 years.
So when did you first get the inkling to, because do you have lawyers in your family or anything? Where'd you get the idea to become a lawyer?
No lawyers in my family. I think I was like the second person to graduate from college from my extended family. But every kid wants to be a lawyer or a doctor, right? I never really thought I could do it. And part of the reason was because I screwed up in college. I was in community college in New York, that's where I'm from. And I did 3 semesters and didn't do well at all. So I dropped out. And I was bartending at a restaurant and a nightclub in New York. I remember.
Now you say New York. Is that New York City?
No, I lived in Hopewell Junction most of my life. That's by Poughkeepsie. So it's about an hour north or so of New York City. But everything north of New York City in New York is upstate. It doesn't matter if you're 5 minutes north or you're 6 hours north in Buffalo. You're all upstate New York. One day, I remember it's a Tuesday because I had worked the Tuesday night shift at the bar. It was a nightclub and also at a hotel. So I had closed early. No one was there. And I ended up going to Barnes & Noble. I don't know why. Just found myself there before they closed. And I'm walking through the stacks, just looking for, I don't know, something. And I stopped in the law section. And I'm just looking at the spines. And I noticed a book, How to Argue and Win, from Jerry Spence. I didn't know who Jerry was. I had no idea. But I saw this book, How to Argue and Win, at home, at the office, anywhere, whatever. So I took it home. I got home, 10 o'clock at night. And I started reading it. And Dan, I didn't stop reading it until I fell asleep at probably 3 or 4 in the morning. And then woke up, went back to the restaurant, and then back to the bar. And I worked a double, and I got home at probably like 10 o'clock at night again. And I just kept reading the book. And I finished it. I didn't go to sleep. I actually finished it. And I remember there were certain things in that book that really spoke to me. Chapters about power and stuff and about speaking. I had that book, set it aside, and I hadn't really made a decision to go to law school at that point, but it was a book that was in my mind and I really enjoyed reading it. So I go back to school in New York, community college. I do okay in the semester, and then I moved to Florida. I happened to move at the same time as one of my best friends and her husband moved down here because he was going to go to law school. I end up going to community college in Broward, finish that up, and I go right to FAU. And at that point, I had seen Rob doing it. I figured if Rob can do it, I can do it. It's something I'm interested in. And I still had that book. Of the stuff that I moved down here from New York, it was probably all of a half a dozen things. And that was one of the things that I brought with me. So I went to FAU and I did 60 credits in 1 year because I wanted to get into law school. And then I got into law school and started at Nova. That was back in 2001, long time ago.
So you got out about what, 2004?
Yeah, I graduated in 2004. I was actually sitting in torts class the day 9/11 happened.
Wow. I was in court in trial on a drug case on the day that in downtown Detroit. And it was so freaky because the world was obviously in chaos. And I'm up at this court. And I remember the judge, his name was Dan Ryan. He was the biggest. He was such an ass. The worst, one of the worst judges, such a complete, he taught down at that Ave Maria Law School that Tom Monahan, the guy that founded, but it's like this ultra religious, super conservative, right wing law school.
Okay.
That was this guy. And he was such an ass to me in court, but didn't stop justice because we got an acquittal on a tough drug case. It was anyways, it's a side note, but that's where I was. I remember going out to my car after leaving the court and I threw my briefcase in my car and I had a Mercedes at the time with and it had one of these very sensitive things and it spilled my coffee, got the sticker, the shifter wet and it didn't function. So I had to leave my car down there in the middle of this chaos zone and pay some tow company to come and tow it because I was afraid, it was going to be like the riots in Detroit, it was just get destroyed. But
wow.
Anyways, that was my 9/11 memory. Everybody remembers where they were, just like, the generation before us knew where they were when Kennedy got shot.
Yep.
Most people remember where they were when the buildings got hit. So let me ask you, did you do anything in law school, to get ready for the stage of trial? Did you mock court, moot trial, whatever the heck they call these things?
Yeah,
Trial ad?
I was on the mock trial team where we went up to Atlanta. I did one of those. Nova was really good. They had a really great track for practical application of law. So I was in the litigation track. So in law school, I did a number of moot court arguments and a number of mock trials. I always knew I wanted to be a trial lawyer. I thought I was going to be a criminal defense lawyer. I actually thought I'd get out, become a prosecutor, then leave and become a criminal defense lawyer. But got my wife pregnant. Second year of law school and realized I wasn't going to be able to take care of a family on $26,000 a year.
Really? Good math.
Yeah.
Trust me, I was a criminal defense lawyer for about 17 years in Detroit before I moved to California. And one thing, it was fun going to court, but man, it was just stressful and it didn't pay very well at all. So I'm excited to have those days for the most part behind me. Occasionally I work on some criminal cases just as a consultant. Volunteer, basically, when it comes to those kinds of things. Not many of my friends that have criminal cases are charging enough to hire a consultant. So I got to so I have to volunteer. I was like, yeah, man, you got to help me, buddy. This is for justice. I'm like, for justice. You got it. So awesome. You get out of law school. How do you start your career out?
Well, in law school, I was actually a law clerk at Liberty Mutual Group Staff Counsel Office. And right before finals, I actually left. Ended up going to work for a plaintiff's personal injury firm as a law clerk. So I got to see a little bit of both sides of it. When I got my license, I started working at Conroy Simberg Gannon, which was one of the largest insurance defense law firms in the state of Florida. So I did that for a few years. Got disgusted because of an adjuster. Really terrible story. And walked in and gave notice and started my practice in February of 2008.
What did that adjuster do to upset you so much that you had to leave?
Yeah, so it was terrible. So I had inherited a case from another lawyer that had moved over to the other coast at Conroy. So I inherited her caseload for West Palm. And one of these cases was a comp claim where an electrician was involved in a motor vehicle crash. And the crash happened about 4 or 5 weeks after we had a string of 3 hurricanes in Florida in consecutive times. It happened a few weeks after that. So when I get the case, I'm looking at it. He's on total disability right now. He's not able to work. Legitimate claims, bad motor vehicle crash, multiple orthopedic injuries, and work comp was paying for all the treatment. And I say, why are you paying this guy this average weekly wage of, it was like $150? Now, Dan, in Florida, there's a max comp rate, but basically if you make so much money, they take 13 weeks of your prior wages divided by 13, and depending on how much money you make, that's what you get paid, a percentage of it. Except if you make more than that, there's a cap. So the cap was, say, $700 or whatever it is. I don't remember what the number was. So that's what he should have been getting. After the hurricanes, this electrician, he probably made enough money to get max comp rate in 2 weeks of work. And I talked to the adjuster and I say, hey, you're not paying him right. You should really do this. We're going to lose a trial. She says, okay, don't worry, I'll pay him. I was like, all right, well, why haven't you paid him yet? She said, I didn't like the guy. That's what she told me. I didn't like the guy. She had never met him. They hadn't even taken a deposition of him yet. She just said, I don't like the guy. Well, she didn't give me permission to cave and pay it until we were like 2 weeks from trial. So what happened was I got the checks, interest, attorney's fees, everything taken care of. I literally put it in an envelope and licked it myself, and I mailed it to defense counsel. And I walked into the partner's office and gave notice and said I couldn't do it anymore because that one adjuster destroyed this man's life. Because during the about 7 or 8 months of when he wasn't getting paid correctly, he lost his cars. His house was foreclosed on. His wife left him. He had to move from Palm Beach up to Orlando to live with his parents and had to commute down to see his children in Palm Beach every other week, all because an adjuster didn't like him. I was disgusted. And I swore I'd never, ever, ever help an insurance carrier again.
I think that's the right move. I never had that experience, but I agree. I never helped the insurance carriers. I'm only for my side. So, Tim, you get started, but you've been an avid student of the game for a long time. So I want to talk to you about the different classes, schools that you've participated in we talked about Trojan Horse a little bit, and it was a very long time ago. But other than that, you've also done a lot of other stuff. So give us some idea of what you've done to try to get better at your craft.
Sure. I truly have done tons. So it started off with me, I didn't know who Jerry Spence was, but I had that book. And I remember back in 2016, I wanted to learn more. And I started Googling different trial colleges and different things. And I had already done the NITA programs. I thought those were great, the 8 to 10 day full mock trial ones. Taking some of their deposition, CLEs. They were all live back then. Nothing was by Zoom. And I found Trial Lawyers College. Solo practitioner, I couldn't go out there for 3 weeks. But what I was able to do was go do one of their regional programs. So that's what got me started. I went and did the opening statement regional in California. Can't remember which one it was, but it was January of 2017. Learned a lot. Met a lot of people there that I'm still friends with now. And then after that, all I wanted to do were seminars. All I wanted to, but not the lecture stuff. I never really got much out of lectures. You hear someone talk for a few hours and maybe you remember one thing. You put somebody on their feet for a few hours and it's going to get in there. You're going to struggle. You're going to feel terrible. You're going to feel like you don't know what you're doing, and then something's going to click. And the next one I ended up doing was I did yours, Trojan Horse, when you came on down. I had a ball doing that. I loved how you taught witness prep. I thought that was one of the greatest things. We actually brought one of my clients down
during that class
for witness prep.
How about that?
Yeah. Yeah.
Real clients.
Yep.
I've gotten back to teaching my witness prep.
Yeah.
Which I'm pretty stoked about because it was like, a lot of people say it's one of the best things I ever did. And like, I'm going down to this, to Angel Reyes' law firm. They might call Reyes Brown, but in Dallas, in like the 22nd, 23rd, I'm doing a 2-day workshop boot camp for a bunch of their lawyers, teaching them witness prep and direct examination. And because I think it's just the most important, essential skill for a new lawyer to learn is to, really get their client's story. Plus, if these little cases that people are working on, these $25,000 policies, if the client does great in depo, they're going to get the policy. if they suck in depo, they're going to have lots of litigation and they're not going to collect any money and they're going to have to really work to get the money. So I just think it's such a key skill. And then the young lawyer really learns how to get the story of what happened to their plaintiff. And so the story resonates with them. And so they can't really fight for somebody until this story, really, for me at least, until their story resonates with me. Now I'm like, okay, now I'm pissed. Other than that, it's just like something that happened to somebody else. So
I've said it many times, dude. Up until you created TLU, I thought your biggest gift to the legal community was witness prep. I've used it since day one. I've taught paralegals how to do it. I've taught my wife how to do it. She's a clinical mental health counselor. I have been speaking your praises, and we've been using it a lot. Very, very effective.
And just on a note, too, with the Trial Lawyers College. So Tim almost ruined Trial Lawyers University because he showed me he goes, Dan, before you started Trial Lawyers University, when Trial Lawyers College was in this big lawsuit with each other, I texted Joey Lowe and I said, hey, you should just call it Trial Lawyers University. And you know what? He didn't do it. And then, and I remember you showed me that text. It was literally a week after that because us having any communication that I bought triallawyeruniversity.com for a whopping $9. It was like because I bought the caseanalysis.com. That was, what we were doing before on the, virtually that website cost me like $2,500. So the fact that somebody had squatted on that one, but not Trial Lawyers University was a blessed miracle for me. And so had Joey taken your advice, there might be a Trial Lawyers University, but it wouldn't be the one that you're talking to right now. I don't know what to call myself. I can't imagine not being Trial Lawyers University because it's just a perfect name for what we do and all the different thought processes, because Trial Lawyers College or Spence Method, whatever has it, their core philosophy of psychodrama and whatever it is that they teach there. Or like the Reptile has their core philosophy. You don't do it this way, you're committing malpractice. And, a lot of these places are like that. You must do it my way. And so Trial Lawyers University brought together like all the greatest minds in trial to give their perspective. And then everybody comes to it, like, pick your perspective. That's what I teach now. I'm like, hey, this is my best thought, my best idea. I ain't saying this is the only way to do it. I'm saying this is one way to do it. Take what you want from it, adjust it, throw it away. That's your call. I'm just here to give you my best thoughts on the issue. So anyways, I just wanted to shout out to Joey for having enough foresight to not buy Trial Lawyers University, waiting for me to take it so I could do with it what I had. Because, he's maybe a little busier when I had time to put 12 hours in a day for the last 6 years. So anyways, that's a side note on that story. What else have you done?
So I don't know if you can see.
We can see your
podcast,
your bookshelf with all your books.
It's ridiculous. So I've spent tons of time learning. Well, first off, I worked with you. I did when you worked with other people when it came to opening statements and framing cases. I've probably got, at least 2,000 hours into practice of all of that stuff. But I really, Nick stuff from Trial by Human really resonated with me. I love his books. I talk to Jacob routinely. I've actually gotten involved in cases with them. They've asked me to come in. I love that. Reptile never spoke to me. I've read it. I've looked at it. It never really did much for me. It felt too cold. It didn't feel like I'm being a human. It just didn't work for me. But I really like the psychology stuff. Mark Lanier is about the only lecturer that I actually enjoy listening to. I've used a lot of stuff. In fact, I used something that Mark taught in one of his things at the last trial that we just had with the skeleton.
And the red tape.
Yeah, it worked really well.
Well, it helps when you get entire body's injured. I mean, it doesn't help the client, but it helps the demonstrative.
No doubt about it. Yeah, that unfortunate skeleton had a whole bunch of red on her. And then we're constantly working. I've done more before GSM and Trial Lawyers Split. I had done some more Trial Lawyers College things. I was invited out to Jerry Spence Method one time for their instructor training. I was supposed to go teach one year, but unfortunately 2 days before, my wife and daughter got COVID, so I wasn't able to go out there. That was a really big bummer for me. And then I've been to TLU Vegas. I'm on the board of Palm Beach County Justice Association, and over the past 5 years, we've created a really great webinar program every Friday. Usually every Friday, we bring people on. I've gotten lawyers, yourself, everyone else, come talk. It's all about learning and about sharing.
And you're almost done with your courtroom. So tell us a little bit about that.
We are, which has been a trek. My goodness. We bought this building in 2019 and started plans for 1,000 square foot courtroom. And everything went off the rails because of COVID.
Hey, let's not talk negatively about COVID. It was a great blessing for so many of us in this world. I mean, I always say it's a tragedy that millions of people had to die for TLU to be born. But you know what? The world's going to spin, and you just got to adjust the sails.
This is true. I actually used turning the world back on the axis in closing.
Oh, that's a good one in voir dire. Perfect with just be somehow we can just push a button and turn the earth back on this axis. And this never had to happen. But we don't have the power to do that. All we can do for justice is award money. We call that money justice. Yes, I'm familiar with turning that earth back on its axis.
Yep, I know. That's one of the things I learned from the first Trojan horse thing that we did way back when in Delray.
Okay, so the courtroom's almost done. Is that right? What are the plans for the courtroom when it is done?
So the courtroom is finally almost done after 5.5 years. We have walls up, we have sheetrock up, we have taping done, and they're putting in tile for all the bathrooms because we're building the courtroom along with a bunch of other offices. They're building out about 3,800 feet. So the courtroom is going to be fully decked out with cameras, audio everywhere, full bench, full everything. And we've made it modular. So the courtroom where the judge sits, that's stationary, but we're creating it so that we can have movable jury boxes and witness boxes so we can reconfigure the courtroom to match any courtroom in the country. Because what I find is that when we're prepping and we're getting ready for trial, when we're creating space, I had made a mistake once where I was creating space, we were practicing, and then when we got into the courtroom, I didn't realize that it was reversed. The jury was on the left side, and I had been practicing with everything with the jury on the right side, not thinking about the particular courtroom.
Unbelievable. And what a brain fart.
I know, and I screwed it up. I ended up creating space on the wrong side twice. So we're going to be able to do it because it's so important. If you're going to practice something, you want to practice it exactly how you hope to do it in trial. And that includes literally where the people are, where you're looking, who's in front of you, who's to your left, who's to your right, and who's behind you. So yeah, we're almost done, and I'm looking forward to doing a whole bunch of training sessions. We're going to be teaching people there, and we're going to be bringing in yourself and others to come on in to come teach and learn. It's going to be
fine. Then we're going to have the Florida location of Trial Lawyers University, the South Florida headquarters, which Florida, after California, is my second most populous state of attendees, I believe. A lot of friends in Florida. That's the way I'll say it. I just did a podcast with John Romano earlier. I love that guy. That guy is I consider almost like my adopted father. He's such a great guy. He's such a great teacher. It's always in such a positive mood too.
Yep. It's funny you say that because I feel the same way. I've said it publicly in front on stages. He is one of my most favorite human beings that walk the earth. And just for being a human, and his wife is wonderful. His kids, the whole family. I mean, they are the full package and just wonderful human beings. He actually taught at Chris Searcy. I met him at Chris Searcy's voir dire college the week before I tried my first case many, many, many years ago. And he was so gracious. Afterwards, he sent me outlines. I mean, I had never even seen a jury selection, and I was lead trial counsel. I've actually never sat second chair. I've only been lead trial counsel in every trial I've ever been involved in. And he helped me so much. And then he's always been around, text messages, phone calls, anything you need. I mean, he's a wonderful man.
He's there for you.
Yep.
He's there for you. So you've had some setbacks, as we all have in our trial lawyering career, and even some recently before you really broke through on this most recent verdict. And so that's what I want to talk to you about now because I've worked on a lot of cases with you where we haven't done very good. And I'm like, damn. Oh, actually, before I talk about it, though, let's talk about flying. Because I know you're a new pilot and an avid flyer. So
I am, and so are you. You just got to get on it.
All because of you. If I wouldn't be in my pilot training. I'm so hard to take all that. I mean, it's like between pilot training and golf, like one of those two has to give. And since if I don't spend time on my golf game, I'm going to survive. If I don't spend time on my flying game, that could kill me. So I'm going to put more time into the flying.
You should, man. Yeah, I love flying. I started flying in 1998. I flew for 16 hours and then never flew again. Started skydiving way back then and then had a bad car crash, a couple of shoulder surgeries, a neck problem, which actually helped me with practicing law and being a trial lawyer. Yeah, I got the bug November 2023. Actually, I was talking to Jacob Norman because he's a pilot too. I went and flew, and within a week, I was under contract for a new plane. It's been the best thing that I've ever done for myself. And it's really cool flying in and out for trials myself instead of having to drive for 6 hours or fly into some place and then drive for 3 hours. Fly right into a small airport is really cool.
I'm still learning, making lots of progress. Hopefully I'll have a lesson tonight. If not, it won't be for another couple weeks because I got...
man.
You do.
All right. You're going to have...
Got a lot of...
You got to bring
slammed with work.
You got to fly Alpha Golf to California. And we'll go fly around California when I'm down there for TLU Beach.
Oh, good luck. Yeah, and I'll just do that instead of go and run the conference. This sounds like a lot of brilliant idea, Tim.
You do it after the conference. Don't worry.
Okay. Well, I can't fly it yet by myself. So you'll have to fly to Vegas, and then we'll fly from here. You could just fly it from here to Huntington Beach, so it's there. That might be a better idea. No, this flying thing's been pretty cool, and I wouldn't be doing it but for your influence of saying, hey, you need to learn to fly. I'm getting a new plane. You should take mine from me because, it's a great plane. It's well broken into. And I'm like, sure, well, that's a brilliant idea. I mean, why shouldn't I go flying? And so I don't know what came up with that idea, but people are like, a lot of my friends are like, Dan, you should not be a pilot. You don't have the attention span. But I'm like, I can work on it. I can learn to be a pilot. It just takes a lot of training, a lot of practice, a lot of focus, which I'm doing. I'm doing that hard.
And that's why I know you can do it, because you do spend so much time practicing and focusing and distilling things down. You'll be able to do it.
Just got to put the time in.
Yep.
And so you have to practice in the deposition. You practice in motion hearings. You practice at the grocery store. That's why you have a family. You practice on them. You have to keep the skill up or it erodes. It's simple as that.
Somebody give us an overview of this case.
Or I call wowing it. And what I mean by wisdom of the wise is, why are we still right in spite of this fact?
These are just some of the clips when I was cross-examined 10 years ago, remember that.
About 11 o'clock at night, and he leaves this message. I got a brilliant idea. Every conversation he starts, I have a brilliant idea.
Well, welcome, everybody. We've got a good crowd here today.
So let's talk about this verdict that you just got a couple weeks ago, your breakthrough verdict.
Or you asked me about talking about the setbacks.
Well, we talked about the verdict first, and I'm going to talk about the setbacks. So, because it puts the verdict in perspective.
Yes.
All right. So what was the case about where you got the verdict?
It's a really terrible one. Obviously, you don't get $92 million if it's not
A serious, tragic,
the
catastrophic case.
Wonderful person. She's a musician. Used to be able to play almost all instruments, sold out the Hard Rock. She's really good. And it's a trucking case, flatbed dump truck and versus a minivan. So it's back in May of 2016, May 1st, actually. Client and one of her best friends, they had gone out to New Orleans because they wanted to see Stevie Wonder. See, a month before, they had gone in together and seen Prince. And then 3 days later, Prince had passed away. My client's pastor, her friend, she's like, listen, Stevie ain't getting any younger, and I want to see him. So they go out. They get to New Orleans for the concert. Unfortunately, he gets rained out. Can't sing. His equipment gets wet, screwed up somehow. So they get back on the road. They get back on the road around 1, 2 in the afternoon. They're driving from Louisiana to Georgia, where they live, and they're coming through Suwannee County, Florida, on I-10, one of the big interstates up there. Around the time they're having lunch, the defendant driver, he wakes up at his mom's house, and he's in his late 40s, I believe, and he starts drinking beer, starts drinking liquor, and he continues to drink, so much so that at 4 o'clock, he claims that he goes to sleep because he needs a nap. He wakes up and he gets on the road. No, the construction company he works for is in Georgia, and he's coming from Georgia to Jacksonville through Suwannee County, Florida on I-10. 8 p.m., he hops in his truck this flatbed dump truck, 26,000 pounder. So you don't need a CDL, commercial driver's license, to drive it. Gets in and he's on the road. He's going on I-10, and he claims that he feels the truck pulling to one side, pulling off the side of the road. He gets onto the shoulder, gets out of the truck, goes around, and his way of checking tires was to kick them. Literally kick them, like what you see in the 1940s movies. Does nothing else. Doesn't find a problem with it. Gets back in the truck, puts it into gear, and he starts moving, and he sees on his mirror, his big driver's side mirror, there are headlights coming on the highway in the right lane. Now, there's only two travel lanes at this part of I-10. He sees it coming, he pulls out anyway. He pulls out in front of a blue minivan, and the minivan swerves to the left, hits the brakes, couldn't get out of the way. The front passenger side hits the rear driver's side of the truck, and the minivan spins and then flips over. After the thing stops moving, stops rolling, the tires explode. The client looks over to her passenger. Her passenger is in between the headrest and the ceiling of the vehicle, of the van. She's like, I'm going to get you out. I'm going to get you out. Don't worry. She gets out of the van, and she's screaming for help. The only other person's on the side of the road, tall black man. He turns away from her and just walks away. She goes over. She's saying, hey, wake up. Passenger's not waking up. Next thing she remembers, there's two guys in LeBron James jerseys and a lady with her saying, hey, relax. We're here to help you. She's screaming for a friend and her dog. Her dog was in the van too. Police officer comes to the scene and says, hey, how many bodies we got? The lady holding the client, she's like, no bodies. People. She's alive. She's in and out of consciousness, or at least she doesn't remember. She loses time. Next thing she does know is she's being loaded into a helicopter, and she's flown to UF Shands for treatment. She doesn't remember much about that. Doesn't remember much of what happened when she first gets to the hospital. But man, she injures her neck, her back, her head, her shoulders, her knees, her elbow, her thumb, her wrist, and major orthopedic injuries that develop immediate and over time. But the worst thing happened to her when she was inside the hospital. She keeps asking for the nurses, the doctors, anyone she can get to listen to her, hey, how's my friend? And they kept telling her, we're working on you. She was taken to another hospital. Well, now it's a couple hours into it, and she's been admitted, and she's in her room, and she's got the TV on, and the news comes on. And they start talking about a fatal crash on I-10. She puts two and two together. She's like, well, I'm alive. My friend must be dead. And she was right. And at that point, she had a mental breakdown. She tried to hurt herself. She was kept in the hospital for a number of days because of it. And that was just the beginning of the terrible, terrible psychological trauma that she suffered because of this crash.
That was the beginning of psychological trauma, but what were her physical injuries?
So like I said, she injured her neck. She had multiple neck surgeries. She injured her back. She had multiple low back surgeries. She had elbow surgery, thumb surgery, multiple shoulder surgeries. One doctor actually said another doctor screwed up a surgery. She had multiple knee surgeries. It was really bad. She had over 300 different medical appointments and procedures and surgeries. She had 16 full orthopedic surgeries and dozens of other procedures, injections, rhizotomies, those things. It was really bad. It still is to this day. She can't play the guitar. She can't play the bass. Can't play the drums. She can't play the piano. She can't do any of the things that she loved.
She also had a TBI too. Did you mention that?
She did. She did have a concussion. She was diagnosed with a mild traumatic brain injury. And even our own expert, our own neuropsychiatrist, I don't use neuropsychologists in cases, but we have a neuropsychiatrist. He actually testified that she only had a mild concussion, but she's got permanent PTSD and some other psychological issues. But yeah, it was bad. Imaging studies of the brain were negative, but it was all clinically documented and still suffers from it today.
And where was this case tried?
Tried in Sewanee County, Florida. Really nice place. Older, like an older town. It's been around, well, it's one of the first, I believe, one of the first settlements in Florida. But very conservative, ultra conservative, working class county, really nice people. We were up there for 2 weeks the second time around because we mistried the case in October of last year. People were wonderful.
Why was it mistried?
Well, we mistried it because during jury selection, I did a full day of voir dire, and I was doing some questioning, some discussions on $100 million in non-economic damages. And of the 56, I think, jurors we had, only 2 really gave us pushback. No one else really did. But these 2 said a lot of things that were really, well, potentially problematic. We were all concerned that the whole panel may have been poisoned because of what was said. I mean, one of them screamed at me and said, $100 million means you get $30 million. Are you doing this for free? I mean, it got pretty bad. So we agreed to a mistrial so we could come back and do it again because we were concerned about the problems we were going to have. And that experience helped tremendously because I used what I learned there in the first round when it came to jury selection the second time.
So when you got ready for this jury selection, so what day did this trial start?
This was started March 31st.
Okay, so March 31st, but you were just coming off a couple of, let's just call it non-optimal results.
Yeah,
so
that's a kind way to say it. Yeah, we had 2, one literally back to back. One we finished that Tuesday before I flew to Sewanee on Saturday, and another one we did about 2.5, 3 weeks before. Actually, I remember calling you up and saying, I don't know why the hell you want to try cases, Dan, because I was questioning myself because 2 cases in a row. We had a rear end collision case with a neck surgery, and the jury gave us 100% of the past medical bills, some of the future meds, and then no permanency. And in Florida, you got to have a permanent injury or you can't get to the human losses. You get no pain and suffering damages. They didn't get there. So that was disheartening because that was a client who's got problems. And I really think the jury got it wrong. I really do. And then the next one, though, was really, really disheartening. Some things happened in that trial. It's going up on appeal. So I'll give you the 30,000-foot overview of it.
Called the Reader's Digest version. That's before your time, but go ahead. The Reader's Digest version.
A terrible, unique case where with ground collapsing next to a seawall with major injuries, I asked for $46 million in non-economic, $40 million in non-economics and $6 or $8 million in economic damages. It was a 7-day long trial. Everything seemed to go good for us. And the jury ended up getting the case at like 4 o'clock in the afternoon, which is never a good thing. So they start deliberating. Fast forward till 9:30 at night. They're still deliberating. We're hoping that they're into money by now, right? Well, we get a couple of questions. They ask for readbacks. At 9:30, the judge brings them out, does one of the readbacks, and then says, hey, we're trying to get the other readback ready for you. We were having some trouble because it was in different parts of the transcript. She's like, why don't you all go back into the jury room and come back in a couple of minutes. Let me know if you want to stay tonight or if you want to come back tomorrow. So they go back in and they don't come back out right away. They don't send a note. They don't do what the judge asked. Out of the blue, 15 minutes later, we get a defense verdict. It was very, very frustrating. There were a lot of things that occurred during that trial we think were reversible. And the only thing we can really think about was that it was too late for them. They didn't want to come back. So it was so much easier to check no than to check yes. Because at 9:30, if they checked yes, they were going to have to spend hours dealing with all the medicine and the damages. So that case is going up on appeal, unfortunately. But it was very, very crushing. Very crushing.
Very crushing, getting crushed 2 times in a row. So you get basically punched in the face 2 times in a row. So tell us, what do you do psychologically to ready yourself for that, for this case? Because, that's one of the great challenges of being a trial lawyer is, you get punched in the side of the head on Monday and, Tuesday or Wednesday, you're expected to get back in there with all your confidence and, good morning, everybody. Like this is a truly just cause I'm fighting for here. But it's hard when you're self-image has been, taking a beating like that. So how do you get it back on track? What'd you do to get back on track for this trial?
I actually took a day and a half off. So we finished trial late Tuesday night, and then I told Paul and Audrey, who were in trial with me, like, stay home, relax. We have another big trial starting Monday. Go regroup. Actually, I ended up taking my instrument rating. I went in between two trials. I went and I got my IFR for flying, and I flew. I actually flew a lot. I spent a few hours up in the air just trying to clear my mind about everything. I find that that's the most peaceful time in my life, probably because my phone doesn't usually work when I'm up there, and no text messages, no emails, and I get to think about everything.
Plus, you got to stay focused on flying. So you start text messaging, email. I mean, you can put it on autopilot, I guess, but if you're like at the controls, you tend to lose altitude or the directional when you're text. At least I do still. I'm still not good enough to multitask, but go ahead.
Yeah, you're exactly right. I only do that when I'm on autopilot, but I flew high enough to make sure that I didn't get reception. Really cleared my head. I remember coming back. I got to the office on Friday. I knew I was flying to Sewanee Saturday morning. I was going up there to meet with the client again, some more. She's from Georgia, but she was meeting me down there and wanted to go work on some stuff for the 2 days before trial, basically alone. Andrew Harris, my litigation support and appellate lawyer, and Paul Dozois, trial lawyer with my office. All three of us tried the case together. They were coming on Sunday. So I had a full day to just get back into it. And before I did, though, I went and I had a long conversation with my wife about it. How I was feeling about what was going on, the fact that I just got my teeth kicked in on a case that we really didn't think was going to happen and shouldn't have happened. Really, truly shouldn't have happened.
You litigated both of these cases for like 4 years. It wasn't like you just parachuted in the last week and, had to work some magic.
Yeah.
I mean, you own these cases. These were you. It wasn't like somebody else's mess ups and discovery and the litigation screwed the trial for you, like I see happens, it happens quite a bit.
No, actually, that's not entirely true. It was screwed up because the lawyer that had that case, the
wall collapse?
Yeah, we call it the wall collapse case. He died. He had it for like a year and a half, and he died from a fentanyl overdose. So I took over.
What lawyers aren't using fentanyl these days? I mean, come on, isn't that a typical way to relax?
I took over the case and had nothing. And I had nothing. And I was almost year and a half, 2 years. So after the fall, the whole thing was that the ground adjacent to the seawall collapsed because the seawall wasn't built correctly, wasn't maintained correctly. And it was letting all the sand and the soil out into the canal. And it just happened to be that he stepped on it and it sunk and he fell forward and it was bad. But the lawyer didn't do anything. He didn't get medical records. He didn't do discovery. He didn't take depots. The only thing we found out he did was get an expert. He did have an expert go out. We got lucky. Found this out from the client. And the client ended up finding the expert's report because the lawyer didn't have it in his file. So the inventory lawyer that sent me everything, I didn't even have it. So actually that was a problematic case from the...
All right. That wasn't all your fault, but it doesn't feel any different. You still got demolished. And so you said you're talking to your wife.
Yep.
And
talking to Jeff.
You had to get back on the horse.
Yeah. And that's really what it was. It's just a matter of doing it. I was saying to myself, do I really want to go do this again? Do I want to put myself out there? And
no, of course not. But you have no choice. It's like there's a trial date. It's like
reading everything that happened to her again, and we're talking on the phone and everything. I just started getting fired up more and more and more. We had some major rulings that went in our favor that really helped. And by the time I got to Sewanee, I was ready to go ask for $150 million.
And how did you come up with the value of this catastrophic case? Because those are very big numbers.
Oh yeah. I mean, I golden rule myself. You hear Mitnick? I like using a lot of Mitnick stuff. Keith's a Florida guy.
Yeah, I know Keith, and he's bald like you, so you have that in common.
This is true.
He's actually maybe more bald than you, but you're close. Go ahead.
Golden rule yourself. I put myself in my client's position. I'm like, what would I want? Now, I've had a neck fusion. I had an emergency 2-level neck fusion. I've had a couple of shoulder surgeries. I've got problems with my knees. I can relate, unfortunately.
Yeah, you got a lot of problems. I'm like, wow.
I can relate to what she goes through, what a lot of clients have gone through in the past. And I'm just trying to come up with what I feel makes sense. I mean, between the neck, the back, the brain. But the biggest thing, the biggest driver was the mental anguish and what she went through. And not because her friend died in the crash, because in Florida, you don't get damages for that. We didn't have a negligent infliction of emotional distress claim, and she wasn't related, weren't married. So what happened to her was horrific. You see, there were news reports that came out, Dan, afterwards that talked about the death, and it had people's names, all three of the people, the defendant driver, Kelvin Slayton, my client, and the passenger that died. And what it said was DUI charges are pending. It didn't say who they were pending against. And there were reports in Savannah. There were reports that's where the client's from. That's where the passenger was from, that general area. She started getting phone calls. She got social media messaging, people going to her house, banging on her garage door, screaming, "You're a murderer. You killed her, the friend. This is all your fault." See, people thought she was the one that was DUI, and they thought she killed her friend, one of her best friends. And that stuck with her. That family wouldn't let her go to the funeral because they thought they killed her daughter. It still happens to this day. Even though the defendant turned down a 5-year plea deal and went to trial, because I'll get into the facts about that, he ended up with 15 years in prison. Even after that, people still thought she was the one that murdered her friend. Just last year, during her friend's birthday, she was a poet, and they were doing something nice for her at a place that she used to go do poetry readings. The client happened to be walking down the sidewalk, and she saw one of her friends that she hadn't seen in many, many, many years, a mutual friend. The girl saw her and just turns around and just walks away. So the client runs up to her and says, hey, what's going on? She turns around and she goes, "Why would I want to talk to you? You killed our friend. You killed the passenger." Even though the defendant's convicted, he's sitting in prison, this woman is still being accused of being the one that killed her friend, and it destroyed her. She barely left the house for the first 5 or 6 weeks after the crash. She doesn't trust people anymore. It's terrible. It's completely warped her sense of relationships. She has zero ability to trust people, anyone but her mom. She doesn't even trust me, doesn't trust anybody. And it's terrible. I mean, being accused of committing a crime, being accused of killing somebody, of murdering your friend, just doesn't leave you. And it hasn't. It's been 9 years. 4 days ago was the 9-year anniversary.
Did that come into trial?
It did. So what happened was, all right, so the night of the crash, the defendant, Kelvin Slayton, he passes all field sobriety tests, right? So he looks fine, except they draw his blood. The results don't come back in for a couple of weeks. During the time, he's actually back working with the company and driving. Well, the blood results come back in. Dan, 0.196 blood alcohol content. The man claims he stopped drinking 7.5 hours before the crash. At the time, 0.196. Ridiculous. I told you, he turned down a plea deal. He went to trial on that fact.
Bad advice. Cost him 10 years of his life.
Yep.
More in prison.
Yeah.
Which probably is not a bad thing.
Yep. Offered 5, he got popped for 15. Can I tell you that he never once, the first time he ever said, "I'm sorry," was on April 1st of 2025 during his examination in this trial. Never once.
Did he come live from the prison or did he zoom in?
Oh, no, he was there live from the prison, and they had him sitting there in a blue button-down shirt and this cardigan like he was,
from Harvard or somewhere?
No, I'm thinking of the guy from the 80s that used to be on television, Mr. Rogers.
Oh, okay.
That's what they have.
Really? They dressed him up in regular street clothes even though he was a prisoner?
Regular street clothes.
Wow,
Yep.
I'm surprised.
Yep. So what happened was And this is the lead into how all this stuff came into evidence, because we got to talk about it all, and we rightfully should have. So when I got involved in the case, I was the third law firm. I had taken over from two other law firms that had handled it first. I find out the client's doing on cruise control 79 and a 70. So she's speeding, coming on the highway, which isn't really that bad. I mean, who doesn't drive 75, 80 miles an hour on a 70 at, 11 o'clock at night? I mean, it's late, dark. There's not that much traffic, but there was some traffic going past the client on the left side doing like 100. So we knew the jury was going to hear that, because that all goes into the forces of the impact, the speeds and everything else. And my concern was that the jury's going to be thinking, if they hear an admitted liability case, which is what we thought, except they had not admitted liability for many, many years. They still hadn't at the time. I was concerned that the jury's not going to hear the full extent of it. So I amended the complaint and I alleged our client's own comparative negligence for speeding and contributing to cause a crash, and said she may have been partially responsible. Now, we ended up with the defendant driver as a defendant for driving, and we sued the employer for negligent hiring, retention, and training. And then we had a vicarious claim for the negligent acts of the employee in the course of scope, and also because they were driving the vehicle owned by the employer. So we had a lot of motion practice on this. The defense tried to exclude the DUI and exclude the death of the passenger completely, saying it's irrelevant. They had not admitted liability. And we still have an apportionment issue because the jury needs to hear everything. I don't want the jury in the back thinking, wait a minute, hold on, she's speeding. Why wouldn't she have caused this? Or, they in their back of their head, we're concerned about what's going to happen if they don't hear the full story. It's always a problem. The defense wants to hide the story from the jury, right? They always want to hide the bad facts. They want to, but we need to bring them out. And that's what I wanted to do. When they file their motions to preclude evidence of the DUI and evidence of the death of the decedent, we first argued, hey, it all has to come in because of the comparative negligence issue. The jury has to apportion damages or liability between the driver, the employer, and our client. And the judge agreed, rightfully so. Because in Florida, there's case law. We're the master of our pleading, so to speak, and we get to plead and try the case we want to try. But she lets in the DUI, but she's excluding the death at first, saying it seems to be irrelevant. Well, we file a motion. The defense had not done a good job in taking the client's deposition. They didn't find out about her being accused of being the murderer and being a killer. They never asked her questions about how it affected her. So they didn't know any of this. And we didn't want to just highlight it in the first round. But when the judge was going to exclude what happened with the decedent, we thought we had to let the judge know. So we did, and we told her what happened about being accused of being the murderer and how it still affected her. It's actually in the some of it's in the medical records, but you got to dig down and find it. There was almost 10,000 pages of medical records, all related to the injuries. So the judge agreed. The judge said, okay, it is part of a mental anguish claim. There's the impact rule in Florida. Unfortunately, our client was sprayed with the decedent's blood at the time of the crash. And with all of the things going on, what it did to her mentally and psychologically, those were all part of her damages. But it wasn't because the person died. It's because of the client being accused of being the murderer. We had agreed we weren't going to bring in or ask for damages because of the relationship that she had with the decedent at all. So the judge agreed. She flipped her ruling, and she's now allowing the DUI, and she's allowing the decedent to come in, the evidence of the death, and how it affected Leslie. One of the other things that happened, though, was they filed another motion for rehearing, but at the time, their motion said, hey, we want to admit liability. Even though we don't believe we're fully responsible, we want to admit liability because we want to keep out the DUI evidence. And they still tried to keep out the decedent again. But they hadn't admitted liability. They hadn't. And the judge refused, rightfully so. She refused to enter an order and give them an advisory opinion. And I had said to the defense with Andrew and I were talking about it, said, hey, you guys haven't admitted it. Are you going to? So they stipulate to 100% liability on behalf of the driver and 100% liability on behalf of the employer for negligent hiring, retention, and training. There'll be more about that, what they did that was so egregious later on. We could talk about it, or maybe we can hold off until I go talk about it at TLU Beach. It's up to you.
We'll talk about it at Huntington Beach, but go on.
All right. So they stipulate to 100% liability, and then they refile their motion saying, we've admitted 100% liability for the driver, 100% liability for the negligent acts, the direct negligence of the employer. We've admitted 100% for vicarious. You can't bring any of it in. We've admitted. So our argument is still the same. Like, no, you can't bring it in because there's an apportionment issue. Because you got to apportion between what the client has admitted to possibly contributing to causing the crash. Their argument was, no. We're vicarious. We accept 100%. So I dismissed the vicarious claim. So we went to trial against the driver who, with the jury heard, he stipulated to 100% liability for driving the car, for driving the truck and being drunk. And we had them stipulating 100% for negligent hiring, retaining, retention, and training, which that was egregious and should have warranted punitive damages. That's going to go up on appeal for how bad this construction company operated. Didn't even know they were a federal motor carrier. So we eliminated the vicarious claim. So now we have three parties, all with distinct, separate causes of action or defenses. And the judge agreed and said, no, it's all coming in. The jury has to apportion the damages. And it worked. It made sense because you know what? They put 50% negligence on the corporation, 40% negligent on the drunk driver, and 10% on the client. And it was a very just result. And that's what we were looking for. And that's why we did it that way. But it was definitely a big battle. It was an interesting battle. And ultimately it came out. So much so that I'm pretty sure the judge actually called Andrew Harris a genius, or said something to the effect of the legal maneuvering here rose to the level of genius. And then she said, I don't know who's going to take credit for it. Talking to Andrew and me. The problem is neither of us heard it because I was telling Andrew to stop with one of his arguments as the judge was talking to us. But it was actually a lot of fun. It was very impressive to do. And I think that ultimately it was 100% the right thing to do from the judge.
The highlight of TLU for me was having the opportunity to network with attorneys from out of state.
TLU has been amazing. I'm so glad I came. It was one of the most inspiring events I've been to. Great networking, great food. It's been amazing. I can't wait for next year.
And you're going to be talking about this case in detail, in depth at TLU Beach, because you're going to do like a live case analysis on it and break down, really talk about really kind of like the turning points of trial between the litigation part of it, the maneuvering you did, some of this stuff right here. And then, throughout trial because you had a tough, like your client had some things about her that would make her maybe less worthy in some parts of our country, perhaps.
Yeah. I don't want to go into too much about some personal stuff, but I will tell you she's African-American female, and there were some other things that came out in trial that should not have come out in trial. In fact, we warned them and said, I'm not asking these questions because I'm not going to get into certain relationship issues. The defense said they wanted to get into it. I told them, if you do, it's going to be bad. And they got into it. They opened a door. They actually opened a handful of doors. They fought hard to keep closed. And it was not a smart thing for them to do with how they did it. But you're right. We had serious concerns about being in Suwannee County. The courthouse is in Live Oak. If you can imagine, it's a beautiful place, a beautiful little courthouse. It really was. It was built in 1905 or 1906 in the segregationist era. It literally has in the back of the courtroom stairs that go up for the loft viewing area. That was disgusting part of our time, but that was where minorities were allowed to watch trials. It was actually kind of fitting. I liked it. And not only that, and then right in front of defense counsel's table was the shackles they put in for Ted Bundy because he was arraigned in that courtroom. years past. We had serious concerns about what would happen if some of the evidence that we knew shouldn't come in did come in, and how it might negatively affect us. And what was really wonderful is that all of that evidence came in, and I've always kind of looked at Jerry's teachings, you got to trust the jury, and we did. And it's a perfect example of why you don't pigeonhole potential jurors when you're doing jury selection. Because if I had pigeonholed jurors in jury selection based on what my fears were, there's a chance we wouldn't have had the same panel. And I don't know if we would have had the same result. I hope we would have, but I don't know. But it just goes to show you, don't stereotype it. Our jury was 3 men, 3 women, all white. All 2 alternates were 2 men, both white. One of them looked like a singer, and he fell asleep second day of trial, so he was allowed to not come back to trial again. But it was a good learning experience, and it just goes to show you, like when people are telling you, Dan, and they say, "Oh, you got to have women on the jury, you got to have Hispanics, you got to have a black, you don't want to have a black person, you don't want a woman," bullshit, absolute bullshit. You talk to the human beings as a human being, not as a lawyer, and find out what makes them tick. And don't pigeonhole people. Don't send somebody away just because they don't check off the box that you think you need, because you probably are wrong. And I that was a really good learning experience.
I bet there was a lot of really good learning experiences in this case. And the best one is learning how it feels to get a $92 million verdict. That's the best learning experience.
Yeah, except at first we didn't get a $92 million verdict.
What'd you get?
Well, so this is what happened. Scared the hell out of me. So the judge is going to read it. Her JA or clerk didn't feel comfortable. So the judge is reading the verdict. And she goes through, and we had asked for $2.1 million in economics for past meds. They gave us 1.8, which was okay, because we put everything in, everything. And I told them, if you don't think this is related, don't award it. It's okay. And then for futures, we asked for $6.1 million. They gave us $500,000. And I think it's for a surgery, that one additional surgery that they think she's going to need. So I'm thinking, wow, we didn't get nearly as much as I had hoped for the economic claim. We didn't have a wage loss claim. She works full time. I mean, she can't sing the way she used to. She can't play the musical instruments, but she went back to being a substitute teacher. So she does work full time. She's not paraplegic, not a quadriplegic. The next question on the verdict form is, first questions are liability, or we went through it. They get the economic damages, and then the question about permanency. Is there a permanent injury? And they answer the question yes, which, I mean, there's really no other answer. They had to come up with a yes with all the stuff she had been through. And then they get to the next question about past pain and suffering. And the judge reads, she goes, $37,500. I almost vomited in the courtroom. Now, where I was sitting I was directly in front of the jury. So, I mean, Dan, if I'm looking at you now on the screen, the jury is probably 8 feet away from me. It's a big courtroom, but the majority of it is in the gallery. It's not real big. Like our counsel table is 4 feet from the judge's desk or judge's whole thing. I'm looking at him. I looked at juror number 1, and I was like, oh my God. Now he's the one that I got the best vibes from the whole trial. When you're trying to read somebody, and I see him look at me, and he looks at the judge, and he shakes his head, and he says, no. Judge is like, oh, did I read it wrong? He goes, 37 million. So I went from almost dying, having a heart attack, and puking my guts out on the floor to almost having a heart attack, thinking like, thank God this jury heard us. They heard us. So I asked for 125 to 175 million in non-economic damages. And I do some things to come up with that, about a penny per second per element of damage, per body part, and come up with it mathematically, because we could do per diems in Florida. But man, I got to tell you, when I heard 37.5, I flashed back to the last 2 trials thinking, how am I doing here? Why? If I can't get a verdict on this case, I'm going to stop practicing law. And then when he said that, I turned around, I was across the table from where the client was. I looked, and her head's down, and she's starting to sob. my eyes are tearing up because I just know she needed this because it's been so long of what's been going on, 9 years.
9 years.
And then she read the futures, and she said $37,500,000. And I'm not good with math, but I'm thinking, holy shit, they gave us half of what I asked for, half of the midpoint of what I asked for. I'm like, that's not bad. I wanted it to be more. In fact, then I start running. Now I'm getting pissed off that it wasn't $100+ million verdict.
Of course. Why would you not be greedy about it? I mean, God, and have another accolade, for goodness sake, not 92.5. Go ahead.
Yep. So then she reads the verdict, and what the jurors didn't know, because the weird thing is the defense is crying foul about this. We were always doing the punitive second phase, and we did jury selection. We talked about it a little bit in voir dire, but not a lot. We didn't want to let the jury know everything that was going on because we only have punitive damages against the driver, not against the construction company. So now they're crying foul saying we didn't tell the jury about a phase 2, which is absurd when they didn't want them to hear it. But we literally read it, and then the judge says, oh, now we got another job for you. You got to do punitives now. So we literally got the verdict, didn't even have a chance to talk or do anything. And I had Paul do the opening for punitive damages. He gets up, he does his opening. Defense does their opening. I put the defendant on the stand, and I go at him fairly hard. And then I asked the jury for $210 million. I asked them just to multiply their verdict by 3. In Florida, the most you can get is 3 times your compensatories and punitives typically. But we would never get anywhere remotely close to that because he's in prison and he has no money. But I asked for $210 million, so I wanted them to make a statement. They came back with $15 million, so we got a $77.3 million in compensatory and then $15 million in punitive damages for a total of $92.3 million. That was fun, except I kicked myself. And if, God forbid, I have to do this again, I'm going to come back and I'm hoping to get more, a lot more, because I have some ideas.
Okay, good. You should be learning from it. But I think if we just collect, give them a haircut, collect 75, we'll be good. We'll be good for a while. We'll see, Mr. Felice. All right, Mr. Felice. Well, we're going to be more in depth with this at TLU Beach, which is June 4th through 7th, which I'm very excited for. And you're going to be doing Nick Riley's TBI masterclass on that Friday.
I'm doing that.
Buddy of yours. And then Nick's doing a TBI voir dire on his recent $23 million verdict. So he's going to do a live voir dire in front of a focused jury. And we're going to have a voir dire track. So we're going to have 8 different great trial lawyers doing live voir dires on a variety of cases, like Joe Freed on trucking, and Ben Rabinowitz from New York is going to be doing a wrongful death voir dire, Kurt Zahner, a premises voir dire, Michael Hill, an elder abuse voir dire. So we got some really cool voir dire teaching coming here at TLU Beach, besides all the fun stuff we're doing, like Ed Saramboli's got a surf camp on Tuesday beforehand. And if you can't make surf camp, then you can just hang out you'll be at the cabana having a cocktail, I'm sure, on that afternoon. I like to make sure when people get from the time they arrive, from the time they leave, if they don't want to be alone, they don't have to be, because, conferences are not really fun. We don't know a lot of people. But if you're meeting people the whole time, pre-conference, during the conference, after doing things like there's on Wednesday, June 4th, if you want, you can go-kart racing with Kurt Zahner. That should be fun. He's taking a group of people out for that.
That's awesome.
I know. And then we got theme parties every night. So make sure you and your lawyers do not be squares, and you bring your, Elvis and Marilyn for Thursday, 80s beach party for Friday, and Saturday is a Rock of Ages. Dress up as your favorite rock star with live band karaoke. So that's going to be really fun. And people are like, I can't sing. I'm like, nobody can sing. If you can sing, you actually, you shouldn't be doing karaoke. You should be on American Idol. So people get up there and just kill it. I'm just like, oh, stop showing off. People get up there and sound horrible and struggle. I'm like, these are my people. All courage standing up there. So that's what we're looking forward to there.
I remember you singing at one of them when you were in your Halloween costume. That was awesome.
Always. People are like, you sing a lot at your I'm like, I know, I got to get the people fired up. And plus I love singing. They're like, you have a very good voice. I'm like, I know that too. I think I do. Well, the rest of the world, who am I asking? I never asked you for your opinion. You keep your comments about my bad voice to yourself, people. My goodness. All right, Tim, how do people get a hold of Tim Felice?
Oh, you can call the office, 561-444-8822, or email me, tim@injurytrialattorneys.com.
All right. And then lastly, we end off every program with our little tutorial on cross-examination, just in case people, repetition is the key to all learning. Some people are like, I really like your cross-examination at the end. Some people are like, God, I've heard it 100 times. I'm like, well, turn it off. I'm like, okay, give me the cross. They're like, oh, I can't do that. I'm like, well, you haven't heard enough times then. Because if you can't do it, you got to you got to practice it too. You can't just listen to stuff and think you're going to get the skill by osmosis. So let me give you a rundown of cross-examination skills that we're going to be learning in this cross. And then I'm going to demonstrate the cross with you. And you're going to be Dr. Felice in a moment. Okay, you ready?
I am ready.
Okay, core skills. Leading questions only. One new fact per question. Looping, which means to establish a fact and repeat that fact in the next statement. Cross-examining in the present tense, which forces you to visualize the cross, forces the witness to visualize it. Most importantly, allows the jury to visualize it or picture the story of the cross. Dropping the taglines like right, correct, isn't it true, true. Dropping all the filler words like and, so, okay. Effectively using a flip chart. That means writing legibly. This isn't a ransom note. And only putting one topic per page. That means you have to write big enough and space it out enough that you just get one topic per page. Being intentional with our emotional state. There's only two dominant emotional states in cross, and they are not anger and frustration. If you ever get to those states, you are giving the witness control of yourself. It's like Joe Fried says, like you give them remote control and they're just pushing buttons. Slowing down our pace of speech and breathing. So many people don't breathe in cross. They try to make a 45-second statement without any oxygen, and it trails off and it loses, and they speed up. They lose volume, they speed up because they run out of air. Bringing the jury in occasionally. Like some people like to ask all their questions to the jury. I think it's more effective if when you turn to the jury and say something, it's got to be something that stands out. Something to remember. It's like, remember this, folks, because this is important. So these, in my opinion, are the core skills. So we're going to do the cross, and then we're going to be done. Are you ready, Dr. Felice?
I am ready, counselor.
So I know this may not be completely realistic, but just say yes. Some people want to go on, and I get that. But this is for demonstration purposes only.
Hard time.
You got to learn the patterns, and then you can extrapolate from there, okay? Are you ready?
I am ready.
Doctor, you're a board-certified medical expert.
Yes.
To become board-certified, this requires advanced education.
Yes, true.
This education takes place both during medical school and after medical school.
Yep.
And while you were in medical school, you did take classes.
Oh, yeah.
One of the classes that you took was on how to conduct a proper medical evaluation.
Yes.
Okay, so right there, we just learned looping, right? Every sentence began, the last sentence ended. We learned pacing. We learned, to pause intentionally. And at the end of every statement, my eyebrows raise and my hand flicks out, my voice inflects, indicating that this is a question. So those are the skills we learned right there. You're trained that a proper medical evaluation, it must be impartial.
Yes.
So if I would have a flip chart right here, the first page would be blank. I'd flip it over. So at the top, it says proper, and I write number 1, impartial. And I write it in capital letters so that when I put objective and complete, it takes up the whole page. But then I put a number 2, queuing the jury up. Stay curious. More is coming. Doctor, by impartial, what we mean is that you're not an advocate for either side.
Yes, true.
Doctor, you're trained that a proper medical evaluation must not only be impartial, so I turn and look at it and use my hand to point to it, but it must also be objective.
Yes, true.
So now I write down objective, and then I put number 3. And of course, now I'm going to define objective because I use parallel structure, which allows the learning process for the jury to be easier. By objective, what we mean is what you and I mean in the context of a courtroom is different than objective, like in a scientific experiment. By objective, what we mean is that you don't cherry pick the evidence to support a desired opinion.
Yeah, true.
Doctor, you're trained that a proper medical evaluation must not only be impartial and objective, but it must also be complete.
Yes.
And so where the number 3 was, because I wrote a number 3 to create curiosity, then I write complete. By complete, what we mean is that you consider all relevant information.
Yes.
Doctor, the opposite of a proper medical evaluation, one that's impartial, objective, and complete, well, that would be a biased evaluation.
Yeah, I guess so.
Doctor, you're trained and you know that there are certain risks associated with a paid expert's choice to conduct a biased medical evaluation.
Yes.
One of those risks is that the jury could be misinformed. I give that to the jury. It's the first time I looked at it in this piece of cross about the patient's condition.
Yeah, I guess so.
So I flipped a page over. It says biased and then pre-written on it, of course. By pre-writing on the board, though, what it does is it creates intimidation factor for the witness because now they know this isn't off the cuff, and the jury knows this is not, extemporaneous. This is well thought out, and so it's planned, which causes the witness more stress. And then you write misinform, and then you put a number 2, creating a curiosity. Doctor, you're trained and you know. So you're trained and you know. That's called stepping. So if you're trained and you know it, it's like a universal truth. It's undeniable that if a paid expert chooses, this is a choice, it's not accidental, it's not that you're doing this because you're overworked with so many patients, to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition, but they could also be misled. That goes to the jury also, as to the extent of the patient's injuries.
Yes.
So I write misled, and then I put number 3. Of course, that's another stepping. Misled is worse than being misinformed. And guess what's worse and more egregious than misinforming and misleading somebody?
Lying.
You're about to find out. Doctor, you're trained and you know that if a paid expert chooses to conduct a biased medical evaluation, not only could the jury be misinformed about the patient's condition and misled as to the extent of the patient's injuries, but perhaps worst of all, they could be deceived into undervaluing the human harms and suffering that were caused. See, I got a new emotion there. It's called tragic. This is tragic. So then I write deceived. So we got misinformed, misled, deceived. Another example of stepping. So a person would be much more willing to accept that a doctor would deceive them if they believed he would misinform and mislead them. So that's called the stepping move. It's a psychological move I learned from my friend Dave Clark, who'll be teaching the dark arts class in Huntington Beach, and the boot camp before Huntington Beach called the dark arts. Finally, we get to the conclusion. So, doctor, let me ask you this question. That's called the refocusing move. Or can I ask you this? So they should be used at the end of every chapter or chunk of cross because it's like squirrel. Like this is the goal fact, right? On December 14th, 2022, you had a choice to make. So tell us all, what did you choose to do? Now be a good expert and act confused and ask me, what do you mean by that?
Well, I don't know what you mean. What are you talking about? I can't answer that question.
What I'm talking about, so that's called a spontaneous loop. You use the witness's words in your next statement, so it gives it more credibility. What I'm talking about is, did you choose to conduct a proper medical evaluation, one that wasn't, I get to flip the page back over, it makes a lot of noise, impartial, objective, and complete, like you were trained to do? Or did you choose to violate your training and conduct a biased evaluation, knowing, I get to flip the page back over, knowing all the risks?
Oh, no, I did a completely perfect evaluation.
Of course you did.
Biased at all.
Of course you did, because you're not a paid whore. Now, see, that is honestly, I think this is one of the most important things I've ever come up with, because this draws a line in the sand. The right way versus the wrong way. And by doing this cross, you're calling that witness a lying sack of shit, basically. And now you got a chance to prove it, right? And the jury's leaning in because Roger Dodd says, a dog ain't interested in a fish that don't flop. Well, guess what? You got to create the tension in the cross. That's why I asked Panish many, many, many years ago when we first got to know him. I said, Panish, what's your strongest skill in the courtroom? And of course, Panish, you know what he said to me? All of them. I said, okay, big shot. If you had to pick one out of all of them, what would it be? And he goes, cross. I know how to find the friction. And that's what cross is about, friction. If you do it well, the jury's angry and pissed. And that's where the big verdicts come from. And so cross-examination is a critical skill that needs to be developed, learned, and practiced, both in deposition and trial. So, because as our friend Satch Oliver says, depositions are trial. And there's some truth in that. You do great depositions. A lot of times you can avoid trial with a nice settlement and everybody gets taken care of, especially the client. But we have what's called cash flow to keep the business open and operating with those settlements. You get these verdicts. Sometimes they don't want to pay them right away. I assume you haven't collected, they haven't sent you a check. Am I correct?
Oh, yeah, they
Not yet.
sent us a check.
Not yet, but they're in the process.
Check.
Hopefully they called you to ask you for your social security number and some kind of tax forms. That's always a good day. Like, just give me your tax forms.
Yeah, no, that case is going to go up on a bad faith litigation.
Oh, yeah.
Yeah.
Lots going on. All right, Tim Felice. It's been great
Same here, bro.
hanging out with you, but it's time to go. So you have yourself a great day, and I look forward to seeing you in Huntington Beach. And it's gonna be the greatest trial lawyer event you ever been to, because you haven't been to TLU for 2 years. And Vegas is good. People really like Vegas, but Huntington Beach is great. Huntington Beach is awesome, and it's great because it's only half the size, so it's like 600 people instead of 1,200, and it's like it just feels small and it feels connected, and everybody makes tons of new friends, which is awesome.
Cool. I'm looking forward to it, man.
And you're going to get a new t-shirt, not this one, light gray one. So I know you're looking forward to that too. All right. Take care, buddy.
Thanks, Dan. I'll talk to you later.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.